Goddamn Wi-Fi acting up. But look, I'm the G attorney, all right? I don't need a law degree. I'm the G attorney, all right, Ryan? Come over here, nigga. I'm the G attorney. All right. We just keep it G. But let's get back to it.
I've read so many things, I don't know if they're true necessarily, but it seems like your end goal here is to make some sort of show on the prep for this trial, according to news articles that have been sent to me.
Like again, you read so many things about it. That's not my
quote to the Sun is not accurate.
That's not my end goal here.
Okay.
My end goal is to win the trial. Okay. Whether they want to follow me with cameras, they can do that. Are we going to benefit by that? I promise you, as an officer of the court, we have not signed a contract, nor have we been given any financial incentive to do something like that, Your Honor.
Okay. This case isn't going to be your legacy. Okay, you may continue, Mr. Blum.
Yes, Your Honor. So just to focus on what this court actually ordered. So the court may reach two orders. This is a motion to reconsider, right? So to bring it back to what this court ordered, the first finding of this court was that the defendant failed to make a prima facie case that the funds were from a legitimate source. Your Honor, first I would suggest that a preponderance is probably, state would suggest a preponderance, but even if we were using prima facie.
And I'll let you know why I went with that, because ultimately there was some disagreement.
Mm-hmm.
We don't have a statute
Right.
for source hearings. There was some disagreement among the states of what the standard was. And as you know, prima facie is much lower than preponderance. And so ultimately I used the lower standard. So ultimately it would be encompassing both standards. I honestly, would welcome some guidance on what the standard should be for this hearing, because I'm sort of flying blind on this thing, but at the same time, that's ultimately why I fashioned that. And so I understand your argument, but ultimately that was something I did consider.
But yes, and what I think is very telling, though, is that after taking evidence, sworn testimony from Mr. Jones and Mr. Davis, the defendant couldn't even make the lowest threshold of prima facie case that this came from a legitimate source. So, and the reason still remains true. Defendant's statement to his wife that Mr. Jones was a middleman, I think this court really has to consider. Also, as we provided exhibits, it wasn't just some spontaneous lie that he told his wife, as was proffered to this court at the last source hearing. Instead, these schemes, these plans, these attempts to deceive the court have been going on for months and months, laid out on jail calls over and over. Hey, we're going to use this person as a front. We'll use that person in front. This person doesn't want to testify, so we've got to get somebody that will testify. And the sample I gave to the court is just that, a mere sample, mere sprinkling of the scheming that has been going on by Mr. Davis in order to deceive this court as to where the source of the funds come from. And so, the other point I'd make is Mr. Jones lacks any credibility whatsoever based on the evidence that we've heard. Your Honor, I would go so far as to say that he perjured himself. And the reason why is, let's look at the evolution of Mr. Jones's positions. The letter he offered this court is, this is a gift. And I've known Mr. Davis for a long time. We're good friends for a long time. Then his testimony evolved. It started with when Mr. Arnold asked him, are you receiving any benefit? No, I'm not receiving any benefit. Then it goes, when I ask him, well, is there a contract? It evolves to, well, there's no contract yet. Then when Mr. Arnold asks him about, well, on the jail call, we did hear about a contract. Can you tell us about that? And then Mr. Jones tells an incredible story about what they're actually discussing. It has nothing to do with the murder of Mr. Shakur, but it's about a car that Mr. Davis once held, and he needs to get the title cleared. So that's what he's talking about, signing. So, and then this court tried to clarify what Mr. Jones was saying. And Your Honor, you have the transcript. You tell me if you got anything from Mr. Jones's response, because I sure as heck couldn't figure it out. In fact, it's the reason why we asked for the transcript is because, well, maybe I'm not understanding and something meaningful was said. No, it was just nonsensical rambling. And so that's just what happened in court under oath. Now we take the extra court, outside of court statements. We have a jail call that refers to a contract. We have a YouTube interview where he talks about stipulations. We have a Clubhouse interview or a Clubhouse social media post where he talks about, hey, I just received this contract, and as a result of this contract, I'm going to be bailing Mr. Jones out or Mr. Davis out.
Yo, Wack, stay the hell off of Clubhouse when you trying to do some goddamn business or you're trying to do some goddamn crooked stuff. Man, keep your goddamn mouth shut, nigga. So let me give you Wack like I tell everybody else, right? This here, this is the key security to your life, right? This is the Donald Trump wall right here. This right here. You build the wall up to keep the motherfuckers out your business, right? Okay? The internet is your security camera to your life. If you want to let motherfuckers in your bathroom and see you in your panties and bra, you let them in. If you walking around your house with your camera and you showing them all the stuff in your house and they come rob your house, you did that. If you get on there on the internet and you talk about some stuff you don't want nobody to know, you're on the internet. The internet is the security camera to your life. You let what you want people to see, hear, and know. Period. So when your house get robbed, that's because you showed everybody what rooms, what's in the rooms, what they want to steal, where you live, how to walk in. When you doing these videos and you walking in your house and you just got to show all your fucking show off. You got to show everything. You show everything, and then them niggas are sitting there watching like, okay, we got to get that. Okay. So when we go in, so you go over here and the kitchen's there, and you're letting the world into your world. Always be conscious of that. All right? Don't say some shit on the internet you don't want nobody to know. Because once it's up there, it's up there. And we see that people scrub information and get rid of information, but you never know who the hell gonna grab it before you get to get rid of it.
And then after the hearing, he does another YouTube interview where he tacitly admits, yeah, so what if I got this from somebody else? What if I told somebody, hey man, I need $112,500 in order to make something happen, and you'll get it back if I can get that money back. That is a remarkable admission that he makes after this court hearing. And Your Honor, whether or not, and I'll address whether or not
he just said what I said in a very nice way. He said, even after the courthouse, this nigga goes on and make more interviews and makes a remarkable statement. Remarkable statement means this dumb motherfucker went and told on himself.
The legality of the court's requirement, but whether or not Mr. Davis or Mr. Jones agrees with the court's position, they are not allowed to, one, lie, attempt to deceive the court, or two, scheme on jail calls to circumvent this court's rulings. So I don't know what Mr. Jones could tell you that would give this court anything, prima facie, preponderance, anything, to believe that this is from a legitimate source, given Mr. Jones's observable willingness to deceive the court in order to get his deal done. So Mr. Jones has no credibility. Mr. Davis has no credibility when it comes to this, except though I do appreciate Mr. Arnold admitting, conceding that Mr. Davis is a notorious gang leader, that he was the godfather of Compton. I appreciate those admissions, but if anything, I think that should go to the later argument that Mr. Giacomo is going to present, that maybe.
I thought that was dumb of his lawyer too. I really thought that was dumb of his lawyer too, to make an admittance that he was a Compton gang leader and all this other stuff. Nigga, you don't you know you got a trial get ready to come up, you stupid ass? Why would you say that? Like, oh my God. Like, yo, man. Yo, another remarkable statement.
Anything, I think that should go to the later argument that Mr. Giacomo is going to present, that maybe this court ought to reconsider its positions, given these. Though I do appreciate Mr. Arnold admitting, conceding that Mr. Davis is a notorious gang leader, that he was the godfather of Compton. I appreciate those admissions, but if anything, I think that should go to the later argument that Mr. Giacomo is going to present, that maybe this court ought to reconsider its positions, given these concessions today. Mr. Arnold's position has always been you can't trust Mr. Davis because he's not telling the truth. Well, apparently he is telling the truth about being a godfather of Compton, and he is telling the truth about being a notorious gang leader. So, Your Honor, the source of the funds, at least for Mr. Jones, is just not credible. He is not a credible source. Anything that comes through him is not credible, is not reliable. Now, with regards to whether or not the court's has the ability to set conditions on a detention order, I think first and foremost, this court made a finding that a detention order was necessary, right? It wasn't that we're just setting bail. This court found, after lengthy briefing, lengthy argument, given all the factors required to be considered in NRS 178-4853, that a detention order was necessary to protect the public from Mr. Davis. And so one of the conditions for release was that he may not benefit from Tupac Shakur's killing, right? He may not use proceeds from that to make his bail. And I would submit that this court was correct in doing that, because pursuant to NRS 178-4851, subsection 3, this court can set any condition without limitation as long as it relates to keeping the community safe. And Your Honor, I would argue that a person publicly availing himself of funds from the proceeds of a murder that is still awaiting trial is in fact putting the public in danger. After all, when we were here in January making this argument, one thing the state told the court and reminded the court was that the FBI literally had to move a witness based on credible threats from the defendant. Now we're going to infuse him with more funds from proceeds from killing Mr. Shakur. How does that keep the community safe? It certainly does not conform with this court's finding that a detention order was necessary to protect the community. I would also add, Your Honor, that a gift, even if we were to believe Mr. Jones's original story out of the 4 or 5 he told, even if we go with the original letter, this is a gift, Your Honor, that simply does not meet this court's findings that Mr. Davis presents a danger to the community and requires to be detained. Because the only reason why you set a detention order assured by a monetary amount is because the philosophy that, well, he has at least got some incentive to follow the court's orders based on the monetary penalty he will suffer if he violates his court's rulings, right? Otherwise, there's no point to the cash bail, to set a bail. And so if he's just being given found money, $112,500, just because, if we were to believe, again, Mr. Jones's first story, just because he's a gift, he's a great guy, I've known him forever, even that, I think, would undermine this court's findings of a detention order being necessary. But that's not what we have here. Lastly, Mr. Arnold, with regards to the First Amendment, what's curious is that Mr. Arnold suggests a gag order, which actually does trigger the First Amendment violations that he worries about with the bail, the release restriction. Because again,
100% fact. I said that. Like, why would you tell a judge, all right, yo, just put him under a gag order, he can't mention Tupac? That just took away his freedom of speech again. You can't use that as the defense, bro.
The gag order actually does require a strict scrutiny analysis, but a condition of release does not require a strict scrutiny analysis. And as this court aptly pointed out, every court in this courthouse restricts whom a released defendant can associate with, right? And we have that freedom of association, but you can make it as a condition of release as long as you tie it to the safety of the community or the ability to return or the likelihood to return. And here, Your Honor, there is a close tie to be funding somebody because of their retelling of the crime that they are on trial for and the safety of the community, especially given what we know about Mr. Davis being as Mr. Arnold pointed out, a notorious gang leader and the godfather of Compton gangs. Your Honor, is given those concessions, this court ought to be concerned.
A lot of what Mr. Arnold's argument centers on, ultimately in his pleading papers and a little bit of what he's talked about today. We are pre-trial. There's the presumption of innocence at this point. And so, how does the state address that, given that these are convictions?
Right.
These are, well, his story is what got us here.
Right.
And his story, now he's saying, is a total lie.
Right.
And everything that he said is a lie.
Right.
And so, how does the state sort of reconcile those two issues, those two?
Right, and so I guess I made an overly nuanced argument with regard to 42B last time we were here. My point with regards to 42B.
I understand, you can't get the money back.
Yeah,
It's gone,
okay,
once it's posted,
yes,
it's gone.
okay. So then if we just go back to the presumption of innocence, sure, Mr. Davis is presumed innocent. But this court was aware of that when it set its orders in January, and that's why we had a whole hearing, and this court created a detention order and a requirement based on the well-considered factors listed out in NRS 4853 about the danger to the community Mr. Davis posed. That's the reason why. That is the reason why he should not be able to profit from talking about his crimes, not because of 42B, but because this court made a finding that he's a danger to the community, and one of the stipulations of his release tied into his danger to the community is that he should not be using funds from the murder of Mr. Shakur to fund his release. One other thing I just want to clarify for the record is that Mr. Arnold stated that Mr. Shakur has no heirs. He does. I believe Miss Shakur, his sister, is on the line. His brother also. They run his estates, and so just clarification, not for the point of our argument, but just for the clarification purposes. I want to acknowledge them because they've been involved very much through this whole process. But yes, Your Honor, when this court made that order, it made the finding, because this court laid out specifically all the factors, the couple for Mr. Davis, a number against Mr. Davis, and then made its ruling that he should not use those proceeds. And I would assume that's because this court believes, as the state believes, that using funds from the proceeds of the murder does not protect the community.
Mr. Arnold, did you want to respond to any of those points before I move to the state's counter motion?
Yes, Your Honor. Specifically, it seems that this is not a matter of protection to the community or ensuring his presence. What the state is asking for Your Honor to do is simply that my client not make any money off of this case. There's no legal authority that they have cited to that disallows my client from making money on this case. Right now, his son, myself, even he can enter into a contract with any media entity and make money on this case. The court cannot prevent him from doing that, and no one has access to those proceeds until he is convicted on this case. That is just the law. And so why is a bail condition going to his ability to make money? Next, the state says, well, this is a gift, and so there's no repercussions. There's probably been 80 people bailed out this morning. Most of it is a gift, Your Honor. It's going to come from the mother, the father, the spouse at times. A lot of people are getting gifts to pay for the
Sure,
bail.
if my mom bails me out, I don't want her to lose her house.
Right.
If some guy that I think is a front and a bad dude, his words, not mine, bails me out, I don't really care if he loses his money. And so that's, I think, my big concern with that point. I mean, there's other concerns.
Right. But that individual, Mr. Jones, he has recourse against Mr. Davis should Mr. Davis flee or not show up to his court appearances. But he has no reason not to show up for his court appearances, for the simple fact is that's part of the story, Your Honor. That does not make sense.
Talking in circles here. So it's both about, his life story is not about the Tupac murder, but also it's only about the Tupac trial. Is that what you're saying?
No.
Because that's his reason for coming back.
What I'm saying is, Your Honor, the life story of my client is separate from the murder of Tupac.
But the only thing that drives him to come back to court would be that he can only profit from a deal if he's either convicted or not convicted or goes to trial in some way. That's just what you said.
No, that's not what I meant.
Okay.
Well, because the reason why he's coming back is to find himself not guilty on this case. He has plenty of incentive to come back. He's not going anywhere, and you have set the parameters to make sure we know of his whereabouts at all times. That ensures his presence.
Okay.
Additionally, you said in regards to a Nebia hearing that you needed guidance. Many Nebia hearings that we've done on the federal level as an assistant U.S. attorney, what we were trying to determine is whether those funds came from an illegal source. Did they come up from some made-up corporation? Did they come from a legitimate bank account? Or there are records to indicate that this was a legitimate business? Those were the factors that we were trying to get from the source here.
Right, in the federal court, but we don't have any sort of statute or case that says anything about what our source hearings look like.
Right, but we do have those concerns met in this instance. That is, we have a legitimate business, number one. We have a entity, 100 Entertainment, that has been in business prior to the beginning of this case. We have another entity, AG Entertainment Touring, that was in existence prior to the beginning of this case. They made payment to 100 Entertainment in the amount of the bail. Again, for reasons known to Mr. Jones, he asked for that specific amount, and there's nothing illegitimate that the state has pointed out in regards to that transaction. And so since there's nothing illegitimate about that transaction, that satisfies the requirements for the Nebia hearing. Him being a notorious gang leader, that shouldn't deter the court from allowing him to be free. He was a notorious gang leader in 2008. Those days are long gone. He was a law-abiding citizen for many years here in Las Vegas. And so he should be able to go back and again tell those stories. We are not protecting the public from anything. What we have to do again is to make sure that he's going to be present, number one, and that number two, that the community is going to be safe. He has not violated the law in any way.